tonight we're going to talk about some of the emerging issues in copyright and 3D printing. There are a lot of different IP issues, but to give the presentation a little bit of focus and to not try to cover everything, we're just sticking to copyright except for one very, very brief mention to trademark because I absolutely couldn't help myself. So tonight we're going to talk about what is 3D printing, first off. Then we're going to get into some of the copyright basics. Then we're going to look at a couple of different hypos where 3D printing is really pushing the boundaries, especially in the entertainment law arena. And then I've left some time for questions. So let's get started. But actually, before we get started, I just want to tell everyone a little bit about New Media Rights. New Media Rights is a legal nonprofit that provides free and low-cost services for artists, creators, and all sorts of entrepreneurs. We work mostly in the transactional space, doing a lot of contracts and things like that. When we're not doing that, we take what we learn on the ground and we turn it into educational and policy work. And we're also a fiscally sponsored program of California Western School of Law. And because of that, the final part of our mission is really educating the next generation of lawyers to be able to serve this emerging community of creators and makers and entrepreneurs in the way that the new legal economy really demands. So that's New Media Rights. What is 3D printing? So 3D printing is a lot like your printer at home, only a little bit different. So the way 3D printing works is, we're going to bring over this video here. So this is actually 3D printing chocolate. But as you see here, much like your printer at home prints layers of ink to create colors, here what it does, it prints layers of chocolate or plastic or cells or other material to create a design, which you can see being created here. So it's a really interesting way. This technology really isn't that new. Engineers have been using it for decades to inexpensively model various prototypes that they're working on. However, it's only relatively recently that the prices have come down on 3D printers, and they're becoming more and more mainstream because of that. A lot of that is actually being attributed to a lot of the patents on the original 3D printer are expiring. So as patents expire, it becomes a lot cheaper to actually create these 3D printers. So in addition to doing, things like printing cups out of chocolate, because that is an awesome idea, it's even creating cartoons, and it's really creating these awesome new legal frontiers where many of the same rules apply. We've really only had one 3D printing case, and that was quite a while ago before mainstream 3D printing started. But why should entertainment attorneys care? I know when I first proposed this idea, it seemed a little bit off, because much of the 3D printing community is really in the maker space, which is very closely aligned with the digital rights community. We have a kind of long history together, but when I say maker, do folks know what that means? No. Okay, so makers are this emerging community of folks who have really taken to creating things. And it's all about creating things on your own for yourself. So things in San Diego like Fab Lab, where individuals are going to not only create art or start businesses, but also prototype things for the first time, which wasn't available to a lot of small entrepreneurs. But why should entertainment attorneys care if most of 3D printing is this maker community? Well, a large part of the maker community is really passionate about pop culture. So we're seeing a lot of designs. But also, when you have this whole community that has a 3D printer in their home and they're so excited to start using it, they're going to want to start printing stuff, and not just stuff they design. It's actually becoming a huge market. Hasbro has really been at the front of this market. They've probably done the most tie-ins with their products. So this is an example of a tie-in where you can print a Captain America or other Marvel superhero with your face on it. As a kid, that would be amazing. I mean, how many of us when we were kids wanted to grow up to be our favorite superheroes, and now kids can print their face on their favorite superhero. It's an amazing opportunity, but it's also an amazing licensing opportunity. It's a great new way to sell products, usually at a lower production cost, and it's an entirely new market for licensing, which is really, really exciting. But along with exciting licensing markets, comes challenges when it comes to enforcement. When you're dealing with a very independent community that's very tied in with makers, and you add to that this is a really emerging area of law, exercising caution before sending that first cease and desist is incredibly important. And this is not something I need to tell to the more experienced attorneys in the room, but especially to the law students and younger attorneys in the room. I mean, you should always be confident when you send that cease and desist letter that you're making the right legal call. But here it's even more critical, because if you make the wrong legal call, it will probably show up on the internet. It will probably be very public. It will probably be very bad for your client. And it will probably end up, if it doesn't end up on my desk, it will end up on someone's desk at some digital rights organization or a law professor's desk. And you're gonna be greeted with a very on-point response letter that you're going to have to find a way to deal with. So that's not a situation any attorney really likes to be in. So the really important thing here is remembering every time you bring those enforcement actions, because the stakes are a lot higher here than in some other traditional arenas, is to make sure you've got a solid case when you send that takedown notice. A lot of 3D printing boils down, and a lot of the basics boil down to what's known as CAD files. So CAD files are computer-aided design files. It's really like a blueprint, but on a computer. So the CAD file is essentially the set of instructions that your computer is giving to the printer on what to print. But it also, in addition to creating, these instructions, it also has a visual display, much like a blueprint does, where you can physically see what's going to be created. But CAD files can be created in a bunch of different ways. So to talk about the copyrightability, the easiest way to explain it is to divide it up between what type of file we're talking about. So we're going to start with CAD files based on scans. So when you're creating a CAD file based on scans, there are a couple ways to do it. You can literally take what's a 3D scanner, which can either be very expensive, or I've even seen them rigged together with things like Xbox Kinect, those little cameras. I have seen a working 3D scanner put together with one of those and a cord, and it was awesome. Or you can even do it, especially a lot of museums, if you end up having museums within your clientele, a lot of museums are doing it by doing a bunch of photos and then wiring them together within the CAD file. That's another way to scan it. So once you have this scan, is it copyrighted? Is it not copyrighted? Well, classic lawyer answer, it depends. So let's start out with, you created this object and you scanned the object. Do you get another copyright in the file? Kind of. You still get copyright protection in the object, but the file itself, because it's just based on a scan, is a lot like if you were an author and you scanned a page out of your own book and printed out that page. It's kind of the same thing. It's like, yes, you do have the right to copy that from the book, but you don't suddenly have a new copyright in this page. But you still have the underlying rights to enforce if folks were to scan. Yeah.
Wouldn't the analogy be, and I'm probably wrong, but more that you have a, say, handwritten manuscript that then gets printed and copyrighted by the publisher?
Well, I mean, that's one way of looking at it. I mean, copyright there would initially vest in you, and it depends what contract you'd have with the publisher. So it's not quite as clean of an analogy.
Well, you can always set up a company to do your publishing for you, too.
Yes. So I prefer, because there are so many variables, especially from a legal perspective of what did the contract say, who created the company, it ends up being a more complicated analogy, but I think if set up correctly, I think it could be a really interesting way to look at it. So that takes care of an original object that's scanned by you. What about if you create an existing object for someone else? So this is actually one of the only areas where we have exactly one case, exactly one case, Meshworks v. Toyota, that actually addresses this. This is the only real 3D printing case, and it happened, I believe, in the early 80s. And in that case, Meshworks was a CAD, basically they designed CAD files and did 3D printing. They were hired by Toyota to make a scan of the car, of one of their cars, and to say, hey, okay, you're gonna create the scan for us and then you're gonna print them. However, there was some miscommunication, and as it turned out, they were really just creating the scans and Toyota was gonna print them, and they weren't gonna pay Meshworks to create these printouts for them. Meshworks cried foul and said, hey, we created the scan, we get the copyright in it, therefore you can't print off these models of your cars based on our scans. Well, the court said no. And one of the reasons why the court said no was, just although digital modeling can be used to create copyrighted material, it isn't always. And this is much in the same way that photographs can be, but aren't always copyrightable. The same holds true for digital models. So are there CAD files that could be copyrightable? Yes. Was this one of them? No. The other thing the court really invoked here was the classic Feist case, which basically, that's where we get a lot of the sweat of the brow doctrine, saying just because you put in some really hard work doesn't mean you get a copyright. That's not how copyright works in the US. So those two cases are what folks have been really drawing on to make the determination that if you scan an existing object that you don't own, that's owned by someone else, you don't get a copyright in that scan, because it's more of a sweat of the brow situation. However, if someone scans an object without your permission, that could be a little bit more problematic, which we'll discuss in a little bit. The other way you can create a CAD file is designing it on a computer. You don't actually have to scan a real-life object. So this is actually a really interesting situation. So let's say you create a non-useful object, like a chair. Well, if you have a non-useful object with no artistic elements, and the CAD file is really just instructions on how to print that out, there's really no copyright protection in that file. It can really be shared freely. But let's say you have a useful object with some copyrightable elements. Well, the copyrightable elements, as displayed in the file, the design itself will still be copyrighted because it's creative, original work, and it's fixed in this file. But you're in this interesting situation where, and very similar to blueprints, where the actual instructions for putting it together step by step, not copyrighted, but the creative object is still protected. So it's this really interesting space where, especially when you're doing this analysis for your client, you've really got to look at, what are we talking about here? What type of file? How was it created? And what exactly are we looking at in this file? The final way I want to talk about copyright before we get into some infringement scenarios are objects created by 3D printers. Now, this is the one that I hear probably at 3D printing talks I've been to. This is the one where most lawyers kind of sit up straight and start panicking. They're really worried about kind of this end game scenario where people are printing off their clients' copyrighted works off 3D printers. In some situations, first sale doctrine clearly makes certain things not a problem. However, what could be one of the problems that is sharing the file around, since if there are copyrighted elements in that file, we could get into yet another really interesting way of looking at file sharing. Now, this is one of those areas where we'll talk more about the infringement in a minute, but I wanted to raise it as one of the issues that is potentially coming up with 3D printing. Also, and just circling back, so when an object is created by a 3D printer, if it's a scan of something that exists in the real world that you didn't own the copyright to, well, that scan, still not yours, and that object that object is still created from the owner's copyrighted material. So probably a derivative work at that point, probably not covered by the first sale doctrine if you didn't have permission from whoever created the scan and the original design to print that. So that, I just threw a lot of information at you. Anyone have any questions?
Could you draw an analogy between music sampling
Okay.
and 3D printing?
So music sampling and 3D printing is interesting. I was really looking for an example that addressed this, but I haven't seen a file. The closest that I've seen is on a site called Thingiverse, where it's really a Creative Commons-based community where a lot of people are releasing their designs under a Creative Commons license, which is a license that sits on top of copyright law and says you can share my work in certain ways. And what we're seeing on that site is people taking something and taking a design saying, okay, I like that, but I'm gonna change it this way and adapt it. So we're seeing that way kind of organically happen, but what we could see in the future is something where people were taking multiple elements from multiple designs, mashing them up and mixing them together to create something. Now, I think although fair use is always a case-by-case determination, I think we're gonna see some really amazing creative transformative works out of it. Is every work created out of this process gonna be fair use? Probably not, just because but there are going to be a lot of really amazing transformative works, and I can't wait to see how people really start to create these.
Are companies embracing this, or is it like the music industry where they're fighting it? Because the first thing that I thought of, I don't even know if this would be an issue, but toys for kids, right? The Hasbro thing is what reminded me of it. If parents can print off the superhero toys, let's say it's like a file on the internet, and people just start spreading it around like music, Napster, whatever.
Yeah.
And then here you have a situation where before, the only way that the kids could get the toys would be to go to Toys R Us and buy it, but now you've got this file. Has there been anything like that that's come out, or is that even a concern?
So it's definitely a concern. We haven't seen a case of it actually happening and it actually being a thing at this point. There is a lot of concern that, file sharing will happen and that toys will be printed off. I think there are quite a few things at this point to kind of prevent that from happening. First off, when it comes to a lot of home printers, they're just not there in terms of quality as opposed to the industrial printers that are being used through like the Captain America partnership. That's a very high-end 3D printer that's being used as opposed to ones at home. There has been some talk of implementing, and some rights holders are very excited to try to implement DRM to limit how those files can be shared. However, this is one of those areas where if you thought the music community was not crazy about DRM, the maker community is really not crazy about DRM. Because it's been abused so much, and this tends to be a very copyright savvy audience, they're not crazy about DRM being used. So I think the companies that really overemphasize DRM will probably not be the winners in this space. They'll probably, unless they really have the quality to back up what they're bringing, it really is just gonna be an example of not understanding your consumer. That said, I think there are still ways to protect rights. I think a lot of what we're seeing on sites like Thingiverse and Shapeways, which are major sites, especially on Shapeways, are very expansive terms that really get into the specifics of what you are and what you are not allowed to do with files. So I see that happening with files to help cut down on that. I see that as a really realistic possibility, a neater way of handling it within this community. I think this community, the maker community, will respond to it. I think parents will respond much better than having to deal with DRM, especially because so much DRM tends to be very poorly executed and tends to break whatever the underlying creative work is, which is always really unfortunate. So there are definitely some creative ways of handling it. However, I don't think we're going to see another music industry. I think we've all learned a lot from what the music industry did right and did wrong, and I think a lot of rights holders from this point are looking at that as an example and saying, you know, they did some things right, but they also did some things wrong when it came to understanding their audience. So a lot of rights holders are slowly becoming more progressive and really trying to make sure that whatever they do to protect their rights doesn't alienate their consumer, because that's been shown. If you alienate your consumer, suddenly they don't want to buy things from you. So it's just bad for business. That file sharing case of sharing files that already exist. Another thing folks are concerned about is scanning entire copyrightable objects that they didn't create and distributing it. So this could look like any number of things. It could be scanning a Barbie doll and reprinting it. Or it could be, and I think we're much more likely to see it in the Etsy and crafting space, where people will take objects created by other designers, scan them, and reprint their own versions. That's something that's already happening in the crafting space, not within the 3D printing space, but I can see that behavior circling over, and that one's always particularly challenging. I think in the 3D printing space, it might be a little bit less challenging since we're not seeing as much useful clothing and useful objects in the 3D printing space yet. A lot of it tends to be either very artistic or completely in the realm of something that's patentable, or in the realm of something that's just completely and purely utilitarian and not really in the same gray zone that a lot of clothing is. And I also think fair use is going to be a really important thing to remember here. Now admittedly, I am coming from the digital rights space. I'll be very transparent about that. But I think fair use is going to be incredibly important. It's an incredibly important right. And I think we're seeing that it's just, if someone has a fair use case, a strong fair use case, that might not be the right place to have a lawsuit. It might be better to do those stronger enforcement actions where there isn't a strong fair use case and where you're going to have to fight a little bit less to get your client that return. And I think that's something that it's our role as lawyers to bring that up, since fair use is confusing. Very few clients understand fair use going in. So when you can act as the lawyer and as that mediator to say, okay, this is a fair use situation, getting a recovery and return, maybe this isn't the one we go after. Maybe we go after the situation that is a rote reproduction of our work and that is clearly not okay and is clearly copyright infringement. So I think a lot of the 3D printing space, and this is learning a lot from the music industry, is picking your battles with your client, finding the most effective ways to enforce. Which, you know, it's cost effective too, and clients are increasingly looking for cost effective ways to enforce their copyrights.